Danielle Davis, partner in domestic relations here at Burnham Law, talking to you today about how COVID has impacted co-parenting arrangements. In the last 2 years, the entire community has been faced with new challenges, and the legal community has not been an exception. In the issue of COVID, we've had people really coming up to us with conflicts about parenting time, about decisions related to school, attendance to school, whether or not to have a child vaccinated has become a bigger and bigger problem in the community over the last couple of months as children are now qualified to receive those vaccines. I do want to talk a little bit about each of those in turn. The first is the modification or restriction of parenting time as it relates to COVID. At the beginning of the pandemic, we had a lot of people coming in asking if they could modify the permanent parenting time arrangement or seek for an emergency restriction to protect their child because either the other parent had COVID in their household or they weren't taking the precautions as seriously as they were themselves. And ultimately, what we found is that the court really did not find that COVID was a sustained problem that justified a permanent modification of parenting time in most cases, and that the seeking of a restriction really wasn't warranted because while COVID was a danger, and certainly we have seen over the last few years the way that has played out, that it didn't present an imminent danger to a child's physical safety or emotional health, which is the legal standard required to restrict someone's parenting time. Ultimately, where we are today, while the idea of COVID and other factors to how it's handled in a household may be an issue that is discussed factually in a courtroom, it cannot and most often will not be the primary basis of a permanent modification of parenting time or a restriction against parenting time for another parent. The other side of this is school. Over the last couple of years, we have seen parents pulled in every direction when it comes to attendance, whether that's in person, online, some hybrid of the two, and inevitably parents are coming into conflict about what that looks like. Prior to 2021, courts really would not get involved in making a decision about where a child would attend or whether or not they would attend in person. Since that time, the Colorado Court of Appeals has gotten involved and given courts a little bit more authority to make a decision about where a child will attend school and how, whether that's online or in person. At the end of the day, though, that does require involvement with the court. It requires getting the issue in front of a judge and having a hearing, having the judge really listen to your facts and your case in particular, and then give you a ruling that you can rely upon. The next part is the vaccines, and that there is an entire separate video about the vaccination conflict. What I will basically say here is that it is a joint decision-making issue, and if you're in conflict and you can't agree, you will need to get it in front of a judge and have a judge give one of you sole decision-making authority to make the decision about whether or not a child is vaccinated. If you have any other questions on these or any other issues, please go to our website, burnhamlaw.com.
Thank you for watching. Make sure you subscribe. And for more information, go to burnhamlaw.com.